This is a sample chapter from Intellectual Property Law, a practical guide to copyrights, patents, trademarks, and trade secrets. Copyright 2011 by Victor D. Lopez. Performance copyright 2017 by Victor D. Lopez. No portion of this copyrighted book may be copied, posted, transmitted, or otherwise used in any form without the express written consent of the author. A note to my readers. This book is intended as both a primer on intellectual property law and as a general reference for authors, artists, musicians, librarians, entrepreneurs, and others interested in learning about intellectual property law and the processes for obtaining copyrights, trademarks, and patents in the United States and through international agreements. The main text provides a brief orientation on the relevant law and on the process and cost of applying for patents and trademarks through the U.S. Patent and Trademark Office and copyright through the U.S. Copyright Office. In order to make this book as useful as possible as a one-stop reference resource, I have collected and included selective statutory materials, sample forms, and other useful resources in appendices to provide greater depth and context for the material presented in the main text. All of the information in the appendices is available online, but some of it can be very difficult to find even if one knows what to look for and where to look for it. As you use this book, please keep in mind that it can only offer general reference materials and information. While this book will provide you with timely, useful information and show you where you can find additional resources available free of charge from both the federal government and every state, it does not offer legal advice. Only an attorney can provide you with legal advice tailored to your specific needs, and neither this book nor any of the self-help advice offered by various national services that assist consumers with document preparation, including the creation and filing of patents, trademarks, and copyright applications, is a substitute for the advice of an experienced lawyer. About the author. I am a professor of legal studies at Hofstra University's Frank G. Zarf School of Business. I hold a Juris Doctor degree from St. John's University School of Law, and I am a member of the New York State Bar. My professional affiliations include membership in the New York State Bar Association, the Academy of Legal Studies and Business, ALSB, and the Northeast Academy of Legal Studies and Business, NEALSB. I also serve as a peer reviewer for several peer-reviewed journals and have served 2 terms as president of the Northeast Academy of Legal Studies and Business, most recently in 2011 and 2012. I've also served the organization as vice president and as program chair of the 2011 NEALSB annual conference. I've published 5 legal textbooks in the past 20 years, including most recently the 3rd edition of my Business Law and the Legal Environment of Business for Textbook Media Publishing. I've also presented articles at academic conferences and published scholarly articles over the past decade in a range of subjects that include immigration law, bankruptcy law, unauthorized practice of law, state and federal efforts to regulate the high cost of college textbooks, and leadership ethics. Since 1990, I've served as a professor of business for 12 years at SUNY Delhi, and more recently as the dean of the business division at Broome Community College for 4 years, immediately prior to joining the Hofstra University faculty. I've served as a professor and dean at other academic institutions since 1987. Acknowledgments. I am poor in all things, save in the quality of my family and friends. The individuals to whom I have dedicated this and my previous 7 books have had an enormous influence in my life, as have others yet unacknowledged. If able, I hope to correct that in the future. In case that opportunity is not open to me, I would at least like to express my gratitude for the privilege of the transformative nature of their friendship that time, distance, and life can never change. Maria Luisa Seoane, Marisita. José Naveira, Tío Pepe. Maria Olga Naveira Calviño, Olguita. Francisco Naveira, Tío Paco. Claude and Kathy Morell, and Bill Rayner. Table of Contents. Chapter 1. A Brief Introduction to U.S. Law. Chapter 2. A General Introduction to Copyright Law. Chapter 3. Limitations on the exclusive rights of copyright owners. Chapter 4. Copyright ownership, creation, and transfer. Chapter 5. Copyright registration. Chapter 6. Remedies for infringement and criminal and civil sanctions. Chapter 7. General introduction to patent law. Chapter 8. Some financial considerations before applying for a patent. Chapter 9. International protection of U.S. patents. Chapter 10. Trademarks and service marks. Chapter 11. Registration of trademarks and service marks. Chapter 12. Trade secrets. Appendices. Appendix A. Copyright registration forms. Appendix B. Selected sections of the Copyright Act. Appendix C. Sample patent. Appendix D. Selected sections from Title 35 and Title 37 of the United States Code. Appendix E. Notes on becoming a PTDL. Appendix F. English Language PCT application form. Appendix G. Sample forms for request for participation in the Japan-US PPH. Appendix H. Selected sections of the Copyright Act of 1946, the Lanham Act, as amended. Appendix I. 37 CFR Part 2 Rules of Practice in Trademark Cases, selected sections. And finally, Appendix J. Sample Forms MM3. Author's Note. For purposes of this sample chapter reading, I am omitting all footnotes. Chapter 2. General Introduction to Copyright Law. Introduction. The U.S. Constitution gives Congress the power to promote progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Congress exercised this right in passing the Copyright Act of 1790, which was signed into law by President George Washington on May 31, 1790. The act was brief. It fit on a half-page of newspaper. It provided citizens of the United States copyright protection for the maps, charts, and books they authored for a period of 14 years, and allowed copyright protection to be extended for an additional 14-year period. The Copyright Act has been amended numerous times in the intervening years and has grown in both complexity and size. The current version of the Act, as of this writing, is 266 pages, not counting 12 appendices. Although the law has grown in complexity since the first Copyright Act, the core concepts relating to copyright are still relatively simple to understand. In this chapter, we will examine the essential elements of the law and the specific types of intellectual property it is intended to protect. Subject matter of copyright. The subject matter covered by the law of copyright is rather broad and includes original works of authorship fixed in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. Works of authorship include the following categories: literary works, musical works, including any accompanying words, dramatic words, including any accompanying music, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, sound recordings, and architectural works. Copyright protection attaches to original works of authorship fixed in a permanent medium. Note that an original work of authorship is not protected as soon as it is created. Rather, protection attaches when it is fixed onto a permanent medium so that it can be reproduced and perceived by others at a later time. It is not the act of creation, but rather the act of saving or archiving one's creation in a tangible medium that grants copyright protection to the creator. For example, if a poet constructs a new poem and speaks it aloud, no copyright attaches to this new creation. Copyright attaches only when the work is fixed in an existing, or yet to be invented, tangible medium of expression that allows it to be reproduced and perceived by others later. Writing the poem on paper with pen or pencil will suffice, as would recording a reading of the poem on tape or in digital form, saved as an audio or video file on a computer, compact disc, DVD, or some future medium of storage not yet in existence. Likewise, a new dance that is created by a choreographer is not copyrighted until it is saved in some form, such as by being videotaped or by the choreographer writing down the steps in the dance on paper or some other permanent form through which the dance steps could later be communicated by others. Thus, a photographer who snaps a photograph automatically obtains copyright to it when the image is captured on film or saved in digital form to the camera's internal memory, or in an external SD card or some other removable storage. And a writer's words are copyrighted as soon as they are transferred to paper by a pen or other writing implement, or saved onto a computer's hard disk or removable storage, such as burned onto a CD or DVD disc, or saved onto a USB thumb drive or other removable storage medium. Exclusive rights in copyrighted work. The owner of a copyright has the exclusive right to do and to authorize others to do all of the following with regard to the work protected by copyright. 1. To reproduce the copyright work in copies or phonorecords. 2. To prepare derivative works based upon the copyrighted work. 3. To distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership, or by rental, lease, or lending. 4. In the case of literary, musical, dramatic, and choreographic works, pantomimes, and motion pictures and other audiovisual work, to perform the copyrighted work publicly. 5. In the case of literary, musical, dramatic, and choreographic works, pantomimes and pictorials, graphics, or sculptural works, including the individual images of a motion picture or other audiovisual work, to display the copyrighted work publicly. And 6. In the case of sound recordings, to perform the copyrighted work publicly by means of a digital audio transmission. The exclusive nature of the enumerated rights means that no one other than the owner of a copyright and those acting with his or her consent may copy, distribute, or publicly display, publicly perform, or create derivative works based on the copyrighted work. Unauthorized use of copyrighted materials can lead to civil and criminal sanctions that will be discussed later in this chapter. It is important to note that civil and criminal copyright infringement can occur even when the unauthorized use of copyrighted work is made that does not bring any material benefit to the copyright infringer. Thus, while making unauthorized copies of a copyrighted book, music, CD, or of a video DVD for sale clearly involves both criminal and civil violations of a copyright law, so does copying a rented movie to keep for personal use, copying an audiobook borrowed from the library, or burning a CD of one's favorite music to give to a friend. By purchasing a legal copy of a copyrighted work, such as a book, magazine, or legally downloaded MP3 music files, the user generally obtains the right to use those files for personal use only, and not to copy or redistribute them. Thus, you may watch a rented or purchased movie at home and show it to guests in your home for non-commercial purposes without charging them a fee. However, you cannot show the movie in a setting that is open to the public, such as on a projection system in your backyard where everyone is welcome to view the movie. Moreover, the same is true for copyrighted works that is of non-commercial in nature. The performance of an amateur rock band in someone's garage cannot be taped without the band's consent, and if consent is given to tape the performance, copies of the performance cannot be made without the express consent of the band, nor can the taped performance be posted online, broadcast, or played at a public venue without the band's consent. And the same is true for a dance routine, short story, poem, drawing, painting, sculpture, or any other subject matter protected by copyright. This is the end of